Good afternoon, everybody. My name is Sumudu Atapatha, and I'm from the law school. And I'm very pleased to introduce Flavia Agnes today, who was appointed by UW-Madison as a distinguished international visitor. And Flavia is a lawyer at the Bombay High Court and founder of Communalized, a legal and cultural resource center in Mumbai. And Flavia is a relentless advocate of gender equality through the law and a staunch critic of the Uniform Civil Code. She has published widely, and one of her books is Law and Gender Equality, The Politics of Women's Rights in India, which was published by the Oxford University Press. Flavia is teaching an intensive course on law and women's rights at the law school, and we are very pleased to welcome her. Thank you.
Thank you, Sumudu. In fact, it's Sumudu's efforts that have got me here. I was here, I think, last fall for a day, and they felt that I should come for a longer period, and Sumudu has worked a lot on getting me here, and I'm really thankful to Sumudu and also to Rachel for fixing this lecture today, and thank all of you for being here. As preliminary remarks, this paper that I am going to present deals with the issue of gender and identity, gender and minority concerns within India. Before proceeding further, I want to state very clearly that my work is located within India. I cannot even claim a South Asian status or identity, because South Asia is a word we hear when we come here, because in India is India, and Pakistan is Pakistan, and Bangladesh is Bangladesh, and Sri Lanka is Sri Lanka, and basically they are all our enemies around us. So we have this terrific persecution. Many, though others see us as the big brother of the region, we feel that we are constantly under attack, even from a small country like Nepal. So we are in the region. India is to the region what US is to the world. The big brother syndrome, where you think everybody is going to attack you, so you have to strike first. So my paper is located in the Indian context. It talks about a very complicated realm of personal laws and women's rights. Within that, the debate for a uniform civil code. This is about broad spectrum of thought and concerns in which this paper is located. The title of the paper, as you know, From Shahbano to Kausar Bano, Contextualizing the Muslim Woman within the Communalized Polity. Now, Shahbano is a name many of you know. It's like quite talked about in various contexts. Anybody from India or South Asia region would know the name Shahbano. Now, this Shahbano incident happens in 1985, where a Muslim woman comes into the public domain as a victim of her own personal laws. Kausar Bano is a name that we don't know. We have not heard this woman's name because she remains more or less nameless. But the motive of Kausar Bano, again, is a very important motive for India in the context of the Gujarat riots, which occurred in 2002, in the month of February-March, where around 3,000 Muslims were killed. But more important of these riots than the riots of the recent past was the sexual attack or attack of a sexual nature upon Muslim women, where women were raped, women were mutilated, and women were burnt. Now, one motive that has come up in the media and that's been talked about into our legislature, the parliament generally, is the motive of a pregnant woman who was 9 months pregnant at the time, and as she was running away from the attacking mobs, she couldn't run, she fell. Her husband ran further to save himself. This woman was caught, and her stomach was slit open. The fetus was taken out, and the Hindu motive for the rites is a trishul, a three pointed weapon. So the fetus was put on the trishul for public display, and then it was burnt in her presence, and then she was burnt. So that's for us Kausar Bano. So Muslim woman, in fact, gets contextualized between these. One is an event which is more or less nameless, but the event is so gruesome that it has remained in public memory, and the other one is a woman. And the context into which they come into the public domain are very, very different. One, she is the victim of her own, in both contexts she is the victim. In one, she is the victim of her own personal loss, which resulted in the denial of her rights. The other one is, the other woman is the victim of Hindu barbarity, which again sort of gets focused on the body of the Muslim woman. There were many such incidents, but this incident stayed in public memory. So my paper examines the political context into which the Muslim woman comes into the public domain, from the Shahbano case to the Kausar Bano incident, and what exactly happens to Muslim women in the intervening period. More importantly, what is a feminist discourse or feminist theorizing that needs to take place when we talk about gender and women's rights? How do we contextualize Muslim women within a more complex realm or a more complex canvas, where gender and identity both can be placed in the same canvas and not into different canvases? Usually what happens is, one is the domain of the gender and the Uniform Civil Code debate, where all women should have equal rights, and Muslim personal law doesn't give women the rights. The other one is a secular canvas into which we say the riots were anti-minority, very barbaric, human rights violations. But the Muslim woman who is in both the domains is the same woman. We cannot segregate Muslim woman and put part of her into the Shahbano canvas and part of her into the human rights canvas. So if you bring both these women together on the same canvas, then what would be the theorizing? What would be the feminist complex whole through which we gaze both at Shahbano and at Kausar Bano on the same, with the same gaze? How do we do that? And I think in the Indian women's movement, for a long time, the spheres have been separate. The papers can be addressing either Shahbano and the Uniform Civil Code debate, or the human rights violations of Muslims in general and Muslim women in particular. This paper, the aim of this paper is to bridge these two different domains and examine who has played what kind of role. The media, the Supreme Court, the feminist, what kind of lenses do we need to use, and how do we sort of go back to that history and understand it again in the present context? I think that's been one of my personal concerns. Locating myself, let me say that I'm a minority in Indian context, but do not figure into the Hindu and Muslim contestation. Somehow a Christian woman stands outside of this domain because her issues are not political enough or serious enough to have a nationalistic discourse. It's more sort of a ghettoization. There are some tribal, there are some Christians. It's on a periphery. But my sensitivity to the issue comes from the fact that I am a minority. As somebody introduced me, I'm also a gender activist, feminist, have been so for a long time, raised issues and written about it regarding rape, sexual violations, reforms in personal laws, a whole lot of issues. I am also a director of an NGO called Majlis, which provides, which is a legal and cultural rights center. So we also work on culture, on producing films, documentary films, and student workshops, orienting students into the different ways of negotiating art and culture in a much more secular framework. Also, we also run a legal advocacy and litigation help program, where a group of women lawyers help women to access their rights, women from all communities, Christians, Muslims, and Hindus. And so that's the background I come from. At this point, I want to ask how much time do I have to speak?
Half an hour or so to allow for time for questions.
Okay. Because it should not be my paper remains half. Okay. So what the questions that I am raising is, within the confines of an identity that is both rigid as well as fluid, how does a Muslim woman negotiate the state structures and community dictates? What are the contradictory pulls of culture, religion, law, and politics that play upon her life, and how does she position herself within these contradictory pulls? Why does she always enter the political arena donned with a mantle of victimhood? Are there no moments of defiance and resistance? And why do these moments get overshadowed? Who are her allies and who are her adversaries in a struggle for survival? What have been her gains and her losses? How do the proponents of a uniform civil code view her? More importantly, how does she relate to the vocal, visible, and highly articulate women's movement, which brought gender concerns within the political arena with the slogan, "Personal is political"? The movement focused on the overarching hold of patriarchy upon the lives of women and invoked state interventions to sustain campaigns to release women from its clutches. But how has this articulation addressed concerns of women who are at the margins of social boundaries, whose reality is marked not only by patriarchal dominations, but also by racial, religious, and caste prejudices? These are important questions that have haunted some of us within the Indian feminist movement. Within a hierarchy of social relationships, gender concerns are articulated from the context of the mainstream. A slogan coined by women of color in the US succinctly captures this reality: all women are white, all blacks are men, but some of us are brave. Even when gender concerns of the marginalized women hit the headlines, they do so primarily to strengthen the prevailing stereotypical biases against the community at large, rather than the overt pro-women concern. What gets foregrounded is the anti-community undertone. And this has been the case, if I would like to go back on the Shahbano incident. Now, why Shahbano is important? Shahbano is a court ruling that happened in 1985, where a Muslim woman was claiming maintenance from her husband. And the maintenance amount, the maximum that could be awarded under this particular law at the time was 500 rupees. Translated roughly would be $10. What she actually got was 160 rupees. Translated roughly would be $3.50. But this, right, in a way, divided the polity into a Muslim identity discourse as against human rights or women's rights on the other side. Now, Supreme Court upheld the woman's right for maintenance because it was claimed under a secular and uniform statute called Criminal Procedure Code. Actually, Criminal Procedure Code regulates criminal procedures in the code. But in that code, there was a beneficial legislation introduced by the British way back in 1898 as a welfare measure, so that men are pinned with the liability of maintaining their children, their wives, their aged parents, so that the state does not have that liability. And the purpose of 125 CRPC is, if your families don't support women, women will go astray, there will be a social problem, they will become prostitutes or destitutes. In order to curtail that, the men should be pinned with this responsibility. But the amount was so low, as the courts have said again and again, to hold the body and soul together. It's not a right, it's not a dignity, it's just so that you don't die and you don't get into prostitution. You should be given a dole so that you can just survive, put your soul and body together. So she claimed, as a Muslim woman, her rights were confined. She did not have a right to claim maintenance under her own personal laws. There are different statutes or under the Muslim personal law. She did not have a right after divorce to claim maintenance. But Criminal Procedure Code was amended in 1973 to include the rights, the wife. The word wife the meaning was expanded to include ex-wife. Because when a deserted woman went to court and asked for maintenance, if the husband divorced her orally, unilaterally and arbitrarily, and she ceased to be a wife, then she did not have a right to come under the statute. So in 1973 amendment expanded the scope and said wife includes ex-wife. So she asked for maintenance under the statute. She was the wife of a very successful business lawyer in Madhya Pradesh, in Bhopal. And she fought the case and she won. Firstly, she got 25 rupees, then it was increased to 160, 70 rupees. And the matter went to Supreme Court. When the matter went to Supreme Court, the Muslim Personal Law Board, a sort of not a state functionary, but a sort of a confederation of different Muslim sects coming together in the context of Ayodhya, with the demolition of Babri Masjid, etc., taking up issues of the community at large, intervened in this debate and made the debate much more political. Finally, the Supreme Court upheld the woman's right to maintenance. Following this, there was a backlash because the Muslim woman was given maintenance as against the principles of Sharia. There was processions, there was demonstrations, there was a huge outcry, in which Muslim women and Muslim men participated on the ground that Supreme Court has intervened into the right of the community to regulate itself. And they wanted a law to undo the harm caused by this legislation, by this ruling. And what is important is this ruling, which was looking at the maintenance rights of a divorced Muslim woman, made certain derogative comments about the Sharia, about the Prophet, and called for the enforcement of a uniform civil code, which is there in the Constitution as an aspiration, not as a fundamental right, but as a directive principle of governance for the state to be enforced when the community is ready or when the nation is ready and feels secure, when the minorities feel secure, then a code can be brought about. So Supreme Court gave a call for the enforcement of a uniform civil code, where the Supreme Court was going beyond its confines, because it's not for the Supreme Court to make a call to pass a legislation. It is the prerogative of the people and the legislature. In the context of separation of powers, Supreme Court was going beyond its mandate of interpreting 125, the rights under 125 CRPC. The backlash led to enactment of a new law. Now that law was called Muslim Women, within brackets, Protection of Rights Upon Divorce Act, 1986. 1985 was the ruling, 1986 new act came to be passed. Now this act was, and this whole process was viewed by the human rights and women's rights groups as the state buckling up under the pressure of minority groups and appeasement policy of the minorities, and a violation of Muslim women's human rights. And the Prime Minister at the time, Rajiv Gandhi, they said was trying to appease the Muslims in this manner, as against another political event that took place around the same year, which is, I'm going outside of the realm of my paper, but some of you may know the demolition of Babri Masjid that happened in 1992. But the opening of the gates for public worship for Hindus happened in the same year. The Hindu Orthodox community put pressure on Rajiv Gandhi, the Prime Minister, to open up the doors of which were locked from 1949 for Hindu public worship of the idols that were installed there. So in a way, government was playing this dangerous game of appeasing Hindus at one stroke and appeasing Muslims at the other. But in the culture of the majority, appeasement of Hindus doesn't get articulated, but the appeasement of Muslims stayed in public memory. Now, when this act came, Shahbano was an old lady. She was in her 70s when this actually case happened. And she was defended by a Muslim senior counsel called Daniel Latifi. So Daniel Latifi had fought the case for her. He felt very disillusioned by the new act, and he challenged the constitutional validity of this act in the same year, in 1986. Several other women's rights groups and organizations and statutory bodies like the National Commission for Women, Center for Women's Development Studies, various groups also filed a constitutional challenge. Around 16 different groups filed writ petitions challenging the constitutional validity of the new act. The act was being challenged that it violates equality under Article 14, it violates right to life under Article 21, and it violates the norm of enforcing a uniform civil code under Article 44. These were the main concerns of expressed in the writ petition. What's interesting for me as a practicing lawyer, the political debate actually doesn't matter when you go into court for litigation. As a practicing lawyer, you see how this law is playing out in the courtrooms, and that becomes the concern. Somewhere in the 90s, okay, politically, let me say firstly what happened after this. A wave of Hindu right-wing gripped the country. Hindu right-wing groups got stronger. In 1992, Babri Masjid was demolished. There was a wave of riots in the country, including in Bombay, the place where I come from, which did not witness riots even in 1947 when the country was partitioned. So even in a city like Bombay, about 1,000 Muslims died, Muslim property was lost. At that point of time, we as secular activists, women's rights activists, went into relief work. There was a tribunal set up to examine it. More important and more famous is the Sri Krishna Commission report, which indicted the Hindu right-wing organizations like the Shiv Sena and the BJP for inciting communal riots and for demolishing the Babri Masjid itself. That commission is still going on, but there have been indictments of even people like Chief Prime Minister aspirant L.K. Advani, Murli Manohar Joshi, various other people, Shiv Sena, Bal Thackeray, etc. I forgot to mention one other aspect here. My organization is named Majlis. Now, the Majlis name is not a popular name in the Indian context, and we registered ourselves in 1990, prior to the demolition of the Babri Masjid. But somehow, post Babri Masjid demolition, we got categorized as a Muslim organization because, unfortunately, we didn't even have any Muslim either on the board or in the staff. But the name Majlis, like Majlis is a Urdu term. Majlis means a group or an association as a forum, an assembly. It can have different connotations in the entire Middle East, even in part of Soviet Union, a word very commonly used in North India as well. But all the time, and we got into relief work. Because we got into relief work and we have a name like Majlis, we got branded as Majlis equals Urdu, Urdu equals Muslim, Muslim equals terrorist. So that's the kind of range in which you position yourself and all the time. Look, we are not Muslims, we don't have any Muslims. All the time, the state inquiries and everything possible. We need a foreign contribution regulatory act number in order to get grant. So they said, open up your accounts, who are the Muslims there, give us the names. And not being Muslim, we don't have that kind of sensitivity. Wondering, like, what happens? Like, the maximum you can go is the name Flavia Agnes. Rest were all Hindu names. Yet you had to constantly validate your citizenship claims that you are not minority, you are not terrorist, you are not this. It is in this context that we started working with Muslim organizations for the commission, the Sri Krishna Commission, as well as the tribunal that was set up. We got involved in relief work. We looked at the injuries of the youth who were fired at blank ranges. A lot of young boys were just for burning tires and showing their protest against the demolition of Babri Masjid, were killed at point blank range. And most of them were from the age of 16 to 22. And most of these never reached the public domain, never reached the newspapers. So that is a first understanding of, like, all is not well, something is wrong here. And what exactly is wrong, we are not able to articulate. But for me, the concern is that we are working with the same groups against which we had opposed when the post-Shahbano claim for a new act was there. They were our adversaries. And now we're working with them in relief camps because they are running the relief camps. Relief camps are run in mosques and dargahs and cemeteries. And we have to work along very closely with them if we want to reach Muslim women, because Muslim women are part of the Muslim community. So that's the first dilemma, that should we not? Should we have a separate entry? How do we enter? How do we reach the Muslim women? Why should Muslim women trust a group which is predominantly Hindu? Though the Majlis name is there, but everybody is Hindu. And Hindus is their enemy. So Majlis name actually helped in a certain sense, that, like, we're not really that bad. We're not Hindu right wing. While we are into this domain, because they're secular, everybody is Hindu. Who will not claim Hindu, but they'll say we're secular. But if you're Muslim, then you have to be Muslim secular, Muslim-secular. In the eyes of the secular groups. Oh, you're Muslim. Or you're Christian. Are you a believer, not believer? Are you really secular? Whereas Hindu, you're the norm, you don't have to prove anything. You're Hindu, is secular, is totally fine. There's no problem. And not only Hindu Brahminical, Hindu upper caste people. They don't have to prove anything, so we are secular. And so much so during the riots, when I had to cross over once, my friend said, put a bindi. And that's the last time I wore a bindi. Because if you're Hindu, you don't have to say your name and you get a passport to pass. But if you're not, then in this whole Muslim-Hindu contestation, there is no space to be Christian. So either you are this side or you're that side. That's how bad the situation was. And that became the starting point for me to understand or go back to the Muslim Women's Act. Now, when the Muslim Women's Act happened, and this, if you ask any feminist, any human rights person, they will give you the same story of Shahbano that I mentioned, appeasement, how Muslims were taken out of, Muslim women became victims, taken out of the state policy, and reversal of the claim for uniform civil code. That story remained in public memory, because people are not so involved with post-Babri Masjid situation. So what I'm trying to say is that gender is not a neutral terrain. Gender gets, like, reformulated in the larger political context of a country. It can be race, it can be tribe, it can be minority, religion. So gender is not a neutral and overarching domain which is constantly stagnant or rigid. It needs to be recontextualized constantly. As far as I am as a lawyer, you somewhere in 1995, 96, I looked at the judgments coming out of this particular act. Muslim Women, Protection of Rights Upon Divorce Act. And the first positive judgment came out immediately a year within passing of the enactment by a woman magistrate in Lucknow, who gave a Muslim woman 80,000 rupees as a lump sum settlement. Because the act said that, after divorce, the parents must support, or the Waqf board must support the woman, and she cannot claim a continuous rights from the husband, because that's against Islam. Marriage is a contract, marriage dissolves here, and the rights are no longer there for a ex-wife as under the Christian law, which is sacramental in nature, did not have a dissolution. English law, if you go back, and forever a continued dependency upon the husband, which is being turned over today in the context of no fault divorce and divorce settlements in this country or in many other countries. That you settle your claims, there's no fault, arbitrary. You can go to court and say, I don't want to live with this woman. Okay, let's divide the property. A similar kind of notion where marriage is a contract under Muslim law. Okay, at this time, you give this woman her due and we end the relationship. Hindu law again was sacramental. There was no divorce till 1955. So in the context of no divorce till 1955, that forever a dependency upon the husband that he is supposed to maintain. So even when divorce comes into the obligation of maintenance continues till the woman remarries or she's living in adultery. So this entire thing is linked to women's sexuality. Now the Muslim Women's Act had a provision that at divorce, the man's obligation ends, so he must return all her belongings. He must return her meher amount, which is stipulated at the time of marriage. But it's not a divorce settlement, it's a marriage settlement. And if he has not paid off his obligation during the subsistence of marriage, he must pay it now. He must pay for a 3 months post-divorce period, which is called the iddat period, where she's not supposed to be out, she cannot remarry, and it's basically to ascertain that the woman is not pregnant from this man. So these 3 months he has to maintain her. And there was another clause which said that, and he has to provide as per Sharia, as per the particular ayat, that a Muslim man, a pious Muslim man is obligated to give a fair and reasonable provision for the woman. And the word, if I'm not pronouncing it correctly because I do not know Urdu, but it would sound something like matta wa maruf, provision and maintenance, a settlement sort of. So he must be a fair and reasonable settlement for her life, for her future needs. Our next judgment comes in 1988 by the Gujarat single judge says that yes, that is correct, and this woman must be paid 1.5 lakh as a settlement as per his status. In the same year, we have 2 judgments from the Kerala High Court, both division bench rulings, which uphold. So now the whole issue before the judiciary is whether it's 3 month settlement only or whether it is a lump sum settlement for the future. Is maintenance and provision the same or different rights? Is it used very loosely? When we say provision, we actually mean maintenance. Is it and or is it or? Is it maintenance or provision, or is it maintenance? Because the statutory word is and. So does it really mean and, or do you mean or? So the High Court is called upon to interpret English language of conjunctures and disjunctures and or, provision and maintenance, during and for. Is it to be paid for the iddat period, or is it paid during iddat period for her lifetime? So now this is an act. Now important part for me is the community asks the parliament to enact a legislation. Now if you see post independence, we had a Muslim dissolution of Muslim Women's Act, which was enacted in 1939 at the instance of the community legal scholars like Faizi and Tanvi and all. They went to the state and they said, Muslim man can divorce the wife, the Muslim wife can also get a khula, but we want a fask, we want a legal right to go to court for a Muslim woman to get divorce in 1939. At the time when the Hindu woman did not have a right of divorce at all, judicial divorce. The judicial divorce right comes in 1955. And if you say Article 14, equality, the first violation of equality on religious rights happens with the enactment of the Hindu Code Bill, where an entire pluralistic community is turned into Hindu and Brahmanical Hinduism, where they say you go 7 steps for Hindu marriage. Section 7 of the Hindu Marriage Act says you go around the 7 steps, you give the girl an offering which is called Kanyadan, and the sacred fire makes the marriage. And this is 1955, where a whole lot of communities which did not have this ritualistic Brahmanical ceremonies were turned into Hindu. And a lot of communities who had the lower caste communities which had the right of free marriage had different rituals for first marriage of a virgin bride and the second marriage, and there was no fire. Dalits, for instance, do not have fire at all. So everybody had to prove this particular ceremony in order to have a marriage validated, or more importantly, a husband could always evade bigamy law. Though monogamy was prescribed by the Hindu Marriage Act, they could always say, we didn't do this, and we didn't have Homa, we didn't have Kanyadan. So they could always get away from the statutory stipulation of legal Hinduism, a fiction created by the law. It never existed and never exists in the country. So 1955, we had a special Hindu marriage law, special Hindu succession law, etc. And 1986, we have this special law asked by the community. So every time I talk to a group of activists or students or scholars, they always come with the answer that I get is that Muslims did not want to be governed by the state. So they wanted to be out of the state. They wanted their own laws. So they asked for this law. So I said, did they ask, did the board say we are not going to be Indians, and did the board pass the law? No, the board did not pass. They went to Rajiv Gandhi and they asked this. This is the common refrain that is there in public mind. Where did they go? They asked the parliament. I said, did only Muslims vote for it? No, everybody voted. But the majority Hindus or majority Muslims? Majority Hindus. So this is a law enacted by parliament in the process of lawmaking. There's nothing concessional to Muslims. So they mobilized. I said, don't we mobilize when we want an amendment to the rape law, when we want amendment to the Christian law? Don't we mobilize? Suddenly these terms get fixed in secular mind that this was something unconstitutional. But according to me, this was a great opportunity where Muslim community go to the state and ask the state to enact a law, a code, an enactment, which then comes into the constitutional mandate of checking out the fundamental rights, whether it sort of fits into the fundamental rights as per Article 13. Am I becoming too legal at this point? Because fundamental rights can be challenged. If a law can be challenged if it violates fundamental rights. And that is why the writ petitions could be filed, because it is an enactment. My concern here is not that Muslim women went to court and got these rights. And how did Muslim women go? Where did they go? A poor Muslim woman who's deserted from a husband in a small village. Some poor lawyer, legal aid lawyer, or a small level lawyer, he would go to court and ask for her rights under 125 CRPC, as before. Husband would pronounce talaq when maintenance is given to her, and husband would say, now she doesn't have rights because we have a new enactment. That small magistrate in a small court would look at it and say, oh no, like, wait a minute, now if she's not under 125 CRPC right is replaced by the new act, let's look at a new act. And that's where, okay, now she's right for a fair and reasonable settlement. Okay, we're not asking for this 500 or 200 dole, we're looking at a settlement. What's your wealth? How long has it been married? Let's give her a lump sum amount. When that happens, husband goes to the sessions court in appeal. When husband goes to sessions court, he may win or he may lose. The woman's case goes to high court. Either way, whether the husband wins or the woman wins. The high courts, in a series, when I say Gujarat, when I say Kerala, Bombay, Karnataka, Calcutta, Orissa, court after court said, no, this is the correct interpretation. This particular verse has to be interpreted this way. It is not or, but it is and. Maintenance and provision is not the same. By the time I do my study, you have about 15 petitions challenging the constitutional validity of the act. But you also have about another 18 petitions coming from the husbands, appeals, who are aggrieved by the new act. So if the act was taking away the rights of Muslim women, how were the husbands getting aggrieved by the act? This is the first question that should come to the mind of anybody. Why are they getting aggrieved? It's the women who are aggrieved. It's a bad act. It's taking away the rights. And here the husbands, case after case, the husbands are going to Supreme Court. So the Supreme Court sits pretty on this. 18 appeals and about 16 challenges to the Constitution, doesn't do anything about it. So from 1986, when the act gets unfolded, appeals are coming up, piling up, nothing happens. concern for me here is not that women went and got the rights, nor the high courts interpreted it, but this never reached the public domain. None of this story had news value. That poor woman who's now entitled to get 1.5 lakh or 3 lakhs or 5 lakhs lump sum, what are the kind of struggles she must have gone through within her community, within her family, challenging the dictates of her own laws and the community, and where she is doing a sort of a subversion and a resistance to certain patriarchal norms. Makes no story at all. You can say it was final verdict of the Supreme Court didn't come at all. So maybe there are some high courts who are interpreting in a different way. So there's no uniformity in the country. There are like 2 or 3 high courts, like I think Madhya Pradesh, Bihar, and Uttar Pradesh. The only 3 high courts which gave us different kind of ruling. All the other high courts are following each other and giving one kind of ruling. Finally, in 2001, sadly, in the month of the WTC issue, our case gets heard and our judgment comes. Somewhere the Muslim community also is not in a state to oppose very strongly. So how important global and national politics play. Our case is heard in 2000, but the judgment is not come, and people say it will never come, etc. Meanwhile, we publish our book, a small book called Judgment Call. And we have a public meeting in Delhi. We gave a book to all the judges, because the judges also now wondering how exactly to interpret this law. And we said that if you go back to the earlier position, pre-Shahbano, you're going to take away the rights of all these women who have struggled, who have got, at least on paper, 1.5 lakhs or 3 lakhs or 5 lakhs, and putting them back into a maintenance dole of 200 or 300, which has a rider of sexual purity, that if you are adulterous, if you are a bad character woman, you are not entitled to maintenance, because your right to survive is only when you are a good, chaste, pure woman, even after divorce. So you want to put the women back there, and why, as against the right, which is lump sum settlement at the time of divorce, after which she can do what she wants. So, but this never comes into the public domain at all. 2001 judgment is a full bench, constitutional bench judgment, equal to Shahbano. It's called Daniel Latifi versus Union of India. Meanwhile, Daniel Latifi himself dies, his junior argues the case, all the women's groups, everybody argues the case at the Shahbano point. And erasing this 15-16 years of history where the act has actually unfolded. And the husbands are arguing, saying that the act is correct, but the interpretation is wrong, it should be only 3 months. So this Muslim woman has no voice in that entire appeal. She remains voiceless. She doesn't have money to have any senior counsel. Nobody argues for her. There is a secular human rights, women's rights lobby on one end. There is the husbands, lawyers, and the Muslim Personal Law Board. On the other side, where does the woman situate herself? She has no voice except the voice of the court itself. And the court then says, this is constitutional. Since Hindus have their separate laws and Muslims have separate laws, the Christians have separate laws, having a separate law into the personal law regime is not unconstitutional. Court has not taken away, the act does not take away any right. It just substitutes one kind of right with another and a superior right. And hence, this right, the new enactment is not unconstitutional. Sadly, even this judgment does not get media publicity. So much so, even women's rights lawyers are unaware, NGO activists are unaware, Muslim women themselves are unaware. So when a Muslim woman is divorced comes to you, you say, oh, you're divorced now after the new act, you have no right. And there's no point in asking for any rights. So what kind of damage that gets done? And why this is so? When such an important judgment, which is Supreme Court Constitutional Bench judgment, which uproots the Shahbano, which in fact goes back to the Shahbano thing, interprets the new act in a very dynamic manner, remains silent. And that is the concern. Not that the courts did it, courts had to do it. Why is it not reaching the public? In the meantime, what does reach the public about Muslim women? There are 3 important, there are many, but I'll name 3. One is a case of a woman called Imrana. Everybody would have heard of Imrana. Imrana was raped by her father-in-law. And when this report came in the newspapers, some journalist went to some Maulavi and got a fatwa that after her father-in-law rapes the woman, she ceases to be the wife of the son. So the son must divorce her and she must marry the father-in-law. That became a major issue, saying that for the BJP, Arun Jaitley was the law minister at the time, everybody, this fatwa system should be abolished and we should have a UCC, and this is what Muslim law does for Muslim women. So Imrana becomes nobody knows the names of all the 16, 17 cases, 18 cases that went to appeal. Nobody knows the names of these women. But everybody knows the name of Imrana. It's in public memory. If somebody may not remember, but if I put this instance to people, they will immediately recall it. Another instance was a case of another Orissa case, very small, in a small village, Najma Bibi, where a husband was intoxicated, and in intoxication he pronounced talaq. Next day he got a fatwa saying that this talaq is not valid. He started living with the wife, but there were certain community dynamics over there between two warring Muslim groups. Somebody got another fatwa saying that you can't live together. The woman went to court, family court, got order of restitution of conjugal rights, and she could stay there. She's not going to a community, she's not going to Jamaat, she's going to court, and she's got an order. Police protection was sought, a National Commission for Women, State Commission for Women, everybody was involved. She was put in a safe home. Yet it was, so this is what the Muslim law is, that now she must marry somebody else, have sex with him, divorce him, and then come back and live with him, and this is what Muslim law is, and so we should have a uniform civil code. Finally, Supreme Court gives its verdict saying that the Muslim, two people can decide to live together at their own will, and nobody else should interfere with the right to live with each other, whether they're married or not married, in fact. That judgment gets no publicity, nothing. But the issue is in public domain. The third is the most pathetic one, the name of Gudiya. Now this Gudiya's husband was unheard of for about 3 years. He was in the Indian Army, he went to Pakistan border, maybe he was caught over there. She gets married to somebody else, she's pregnant. Now the question is, when he comes back, the first husband comes back, now this woman has got 2 husbands and she's pregnant with the second husband. The media conducts a public trial where this woman is put there because we are so voyeuristic. We want to see the personal lives of Muslim women so much so that we can attack the community with it. So here she says, no, I want to stay with my second husband. The Maulana there says, no, she's not entitled to, because if it was 4 years, then it would be equal to death under the Muslim Dissolution of Muslim Women's Act. This was 3 years. She must go back. Then she must give away the child to the second husband because the first husband cannot accept this child. Then some negotiation takes place and they said, okay, the first husband will accept the child of the second husband. She agrees to go. It's full frontline stories and the media. We all know the Gudiya name, everybody knows. She goes back, she has a child, 3 months later she dies. When she dies, there's only 3-line report, Gudiya has died. Now who killed Gudiya is not important. What is the role each one of us played in the Gudiya drama is not important. The Muslim woman, she has served her role in this unsatiable greed of voyeuristic greed that the public has, that the media has, TRP rating, everything. At this juncture, we get Gujarat riots. Now, after Shahbano, the appeasement of Muslim was the 2 or 3 points on which this appeasement theory is based is Muslims can marry 4 times. Muslims are not bound to pay maintenance to their divorced wives, and Muslims can pronounce arbitrary talaq. We go for relief work after Gujarat riots, where in a particular camp there are like 30 newborn babies under the scorching heat of 45 degrees. Children are born there. Another area where injuries festered, people infested with wounds, as they call this hospital area. So men are sitting there, women are sitting there. Into that arena, you go to the Hindu side, and what they say, oh, they deserved it. They had it coming. You know, they don't want to live in India under the Indian law. They want a separate law. They don't want to pay maintenance to their wives. So injury to a Muslim woman, Shahbano, becomes a denial of rights to a Hindu woman, a Muslim woman becomes a Hindu injury. oh, they had it coming. And in the sense they need to be attacked, they need to be sexually abused, they need to be raped, just because they are not agreeing to have a uniform civil code. That is as absurd as the logic could be. And that Shahbano case becomes a sort of a justification for the entire Hindu Gujarati community. Not that they attacked it, but they condoned the attack with these kind of wordings. But it doesn't stay only in Gujarat. It comes back even in Bombay. Even when we have a meeting, everybody calls me to have a meeting on uniform civil code. And they said if they agree for uniform civil code, the riots may not have happened. It is because they don't agree and they don't want to give maintenance to Shahbano. So according to me, it's a political design. It's a political design. The victories of Muslim women have to be erased out, and injuries of Muslim women must be heightened in order to justify attack on an entire community. Unfortunately, 2002 happened. Even today when I talk, still in people's memory, secular people, human rights activists, women's rights groups, even today we do not want to think about Rani Latifi judgment. We do not want to give any publicity to that women have rights. We still want to remember Imrana and Gudiya in the justification of a demand for a uniform civil code. But at the same time, we sometimes may, as secular activists, women's rights activists, think of Kausar Bano, think of this slitting of, we have done a study of the kind of sexual abuse that happened to women. Most of the women came into the relief camp with bleeding injuries, with splinters into their vaginas, into iron rods, swords, what have you. And that kind of sexual violence which was there at partition in 1947, we did not think that we would live to see the day when it's going to happen again. And this is like public memory. It's like every commission, every group that worked on camps is aware of that. So my concern is that unless you rectify our understanding of Shahbano, Kausar Bano incidents continue to occur, because that middle ground, okay, you have extremists, but that middle ground has a justification which in a way condones what happens in Gujarat. So then how do we look at intersectionality of gender and community? And a lot of work has been done in this country by black women of color, Kimberly Crenshaw, Toni Morrison, this whole debate on Anita Hill case and sexual violence. There's a lot of writing happening there. But unfortunately, in our country, this kind of writing is not there. The Muslim women themselves would lean more in favor of UCC and say denial of rights here, rather than having a much more complex framework in which we can set up these rights. And that's what is needed for us to counter the communal bias.
Can we take about 2-3 questions?
Yeah, we have time.
Are there any questions?
I'm sorry I took a long time, but
No, it's very good.
I had to explain.
So is it hard for you to look at the media without placing any blame on how they play out this dynamic to the public?
Is it hard for me to look at the media? But media does this. This is media's bread and butter. They have to have their TRP rating. They do it for rape. They do it for every women's question. We took the bar dancer issue. This is the same way they do for the bar dancer. It's like constantly. In a way, you think media is supporting you in some spaces given for women's issues, which was not there, say, 20 years ago. But the manner in which it is given, it creates in the public mind notions about women and their sexuality in an extremely negative manner. So how do we change that? I don't know. How do we change that?
I understand you underscore the role that media is playing. How much the Muslim community itself is responsible for what is happening to the Muslim women? The community itself, the Muslim community. Do they take responsibility?
Well, circumstances have made the Muslim community take responsibility to the Muslim women, because after Bombay riots, after Gujarat riots, etc., there's like constantly this flagging that happens where the community is forced to look at it. Like they have this whole model Nikarama debate now, where they released a new model Nikah giving women the right of khula, meher, a whole lot of things that are there. And today, in a way, Muslim community leaders on the back foot because of the consistent riots. It was not a position as a sort of an arrogant position of post-Shahbano. Like Dani Latifi judgment, for instance, there was no backlash after the Dani Latifi judgment at all. And then Gujarat riots and a whole lot of things have put the Muslim community on the back foot. They will not argue that this right is not there or that right is not there. And in fact, there are a lot of Sharia courts which are giving women their rights if they go to the court, but to the Sharia courts. But also, a lot of Muslim women are approaching the family courts for their rights, and there's no castigation of Muslim women because they're going to court. That is not happening.
Is there any progressive women organizations in India fighting for the right of women?
Muslim women?
Yeah,
Yeah, definitely. There are lots of Muslim women's groups today. In fact, there's an all India coalition of Muslim women's groups that are who also want to have certain laws, parts of the certain laws codified, either through the Sharia board or through the parliament. So there's a lot of work that is happening there.
Yeah, I see that the legal rights and the human rights are really at crossroads with each other, and there's no way that we can get out of that. And there is a breakdown of law in both cases, and then at the same time the human rights are violated. How do you really?
I think that's a challenge for us, that we need to have a new theory, a new framework into which we look at both these issues and how well to formulate it. So coming back to your question, if we go back to Shahbano, after all this, when this debate emerged in the public domain, Shahbano came into the public forum and said, if this right is against my religion, I would rather be a devout Muslim than claim this maintenance. Now, this kind of things are going to happen to women if there is kind of polarization of one kind of rights as against another kind of rights. And today, I think the concern here is firstly reform within your own law, reform within Christian law, or reform within Muslim law. Somewhere we need to have that kind of dialogue within the community rather than give this right to a Hindu majority state to beat the community with. And in a way, Christian women have changed the law. They have a new enactment which gives them the right of divorce on the ground of cruelty. In 2001, this law got changed. The Dani Latifi judgment, which gives, apart from Dani Latifi, there's another judgment, Shami Mara judgment, which prohibits husband to pronounce arbitrary talaq. And the talaq has to be Islamic, there has to be arbitration prior to the talaq, he has to give a reason. But now, if these judgments are not publicly in the public domain, people are not aware of these judgments. But if a case comes to us where husband is given a talaq on the telephone, then we will not go on the talaq, we'll just ask for the Muslim woman's right to maintenance. And when he comes and says, I have divorced her, he would have to prove that he has divorced her in the Islamic way and that all the ingredients of a valid talaq has been fulfilled. Now, courts have done a lot in this realm, but unfortunately, the game that media and the public discourse plays does not give space for these rights to be highlighted, to go into the public domain. And individually, as an organization, there's only so little one can do to undo the biases that are prevailing in people's minds, that no, this kind of talaq is not valid. If husband has taken more than one wife, then he has to maintain them on a similar scale. Or in the divorce, in the nikah nama, you can have a clause that he's not going to have another wife during the subsistence of the first marriage, or even their meher amounts to be adequate. Now, all these things can be done if there is far more propaganda about it, either in the public domain or in the communal spaces of the religious itself. I mean, they can pronounce it and say every Friday that, don't deny the women the rights, Quran doesn't say so, we have a new nikah nama, please use that. But that doesn't happen either, and people like me cannot enter that space. I am not entitled. I can work on the nikah nama and get it done, but beyond a point, there is no space for me to enter the legal discourse within the community.
just thinking that when you drew the relation with the Gujarat, right, with that of partition, and I was just thinking of the other side of violence by Talia, and she's continuing working on the narratives of memory, the narration of the memory of women who have suffered violence.
Who is working? Urvashi, okay. Yeah.
Talia.
The many actually, Ritu Menon, Urvashi,
Right,
Latsu, Kamla Vasim, Gyan Pandey.
Right. So, but if we take the case of say Narendra Modi now, right? And I was just thinking that often that is made out in the media is that, look, so and so Ratan Tata is going to Gujarat because he is giving the plot for free, practically, right? And so my question is that there is the general temper in the country today is that economy will erase the memories of violence, and somehow it will just displace it and distribute in a way where equality will, emerge somehow. So how do we kind of and Narendra Modi is in a very powerful position because he's been elected.
Yes.
So the thing is that how do we tie this problem of violence, outright violence, breaking the rule of the law of the country, and yet winning an election and gaining electoral accountability, and then the market, the pandering that goes on. How do we connect these issues in the country today?
We can't connect. We cannot connect. And all I can say is, in a constitution, we have very special provisions for minority rights. Basically, because democracy meant majority rule. Democracy, if you go by sheer numbers, then majority dictates must prevail. And in that context, there is special protection was given to the minorities as a fundamental right. Article 25, 26, 27, 28, even up to 29, 30, minority cultures, etc. Unless they were secure, these rights were secured by the Constitution, they would not be such rights. Secondly, we also have a notion of a basic structure that successive parliaments cannot override what Constitution and Constituent Assembly laid out for different segments of the society, and that's a larger view that prevails, which cannot be undone today. So that's our only hope. When you say Narendra Modi was elected, he was elected, and I would also say that even Muslims voted for him because they didn't want. If he was not voted, if it meant more rights, then better have Narendra Modi in there and lesser rights. It's not that peace and security has come back to Gujarat, and now the recent case of Irshat, I don't know whether you're following that, they killed a 19-year-old girl from a college in Bombay on the pretext that she along with others are terrorists coming to kill Narendra Modi. That was the story then in 2003 or something. Now judicial magistrate has conducted an inquiry and brought out a report that she was kidnapped, she was killed, and she was put there. And to make the story, and so that this police men will get increments and promotions. And that was as bad as it could be at that point. And despite this economic progress is happening. And in fact, the riots of Gujarat, the breaking of the Muslim traders' spine, one of those was trade competitions. The number of eating houses, malls, shops that were burnt of Muslims, that in a way it was an economic setback for the Muslims. And of course, for Gujarat is a trading community, and the trading pattern of Gujarat is the most important, and into which the Hindu-Muslim rivalry was the main aspect of this entire onslaught of the community. Now, into such a situation, there is economic progress, there's development, there's money coming in, there's Ratan Tata coming in, there's a whole lot of things, and you really don't know. And this Irshat stories come last month in the media, after everything else, and there is no accountability except a democratic process of elections. And elections have brought Narendra Modi with a thumping majority in the last elections. Forget the first elections, even now. So there is no answer. An answer must come from the people in Gujarat. The human rights activists from outside of Gujarat going there to do relief work is not going to be the answer. You can have international commissions looking into it. You can have human rights violation commission looking into it. All this means no change within a democratic setup where a chief minister is elected back despite all this. And that's why we have no answer for the question that you are saying, and we're confronted with the same kind of question. Me talking and giving this paper here makes no difference to the Gujarat community. And we're not able to work there at the grassroots.
I have a quick comment, not really a question. Since you're working on women's rights and human rights and all this, I think, in my opinion, to overcome women's rights, to come out of the abusive situation and all that is, women themselves has to stand up. What I mean by that is, in Asian countries, I mean, for the many past years, they were looked down and put down for years and years. So they're kind of like in a way that they don't want to shy, or they don't want to get up and stand for themselves and speak for themselves. I mean, there are individuals getting up and fighting for their rights and all that. But if you ask randomly, like one Tibetan woman, an Indian woman, and Sri Lankan woman, okay, come up, and give them the stage and speak about women's rights, they will actually pass over. No, it's okay. I don't want to talk about it. You do it. So I think the core, the fundamental problem for that is women themselves is kind of, backing up and not really coming forward to do that. I mean, individually there are many, right? But overall, women themselves, I mean, in Tibetan community, same thing. If you give them the opportunity in the stage, like, oh no, not this time, I'll do another time. So I think that is one of the biggest problem that not individually, but overall as a woman, as a community, has to come forward and then have more self-esteem and more confidence in themselves, and then take the stage and come forward and do that. I think that is one important and key issues that to overcome that problem.
I have to say, I think that's very simplistic.
I was just going to say, I wish somebody else would answer this
Very
question.
tricky for a woman to stand up when you're likely to get beaten down metaphorically or literally.
Yeah, I mean, that's what I'm saying. They've been put down for so many years. I looked down upon them for many years. So they're kind of like So, I mean, in Tibetan community, women are coming forward. There are more women association and all that, and they're speaking for themselves and fighting for women's rights. So, they need to be more like, if, my wife is Tibetan, I'll push her, right? Okay, you have to go forward and do that.
Flavia is here. She's not the only one in India.
Well, we have 4 parties in our country headed by women, 4 political parties. A speaker of a Lok Sabha is a woman at this moment. And what I'm trying to say is that politically, at one level, maybe at the level of elections, not so many women, but somewhere we have a culture where a lot of women are in the public domain. High Court, Supreme Court, local legislatures, state legislatures, political party heading. We have Sonia Gandhi, we have Mamata Banerjee, we have Jaya Lalita, we have Mayawati. Mayawati was a prime ministerial aspirant of the last election, for instance.
that's
A Dalit and a woman. So and the statues controversy and all that. So nobody can ever forget that Mayawati was the chief minister of the largest and the most backward, in a way, and most backward for women's rights. She is heading that state. As a Dalit and as a woman, and not doing too badly. Everybody wanted to rally with her to defeat the Congress. That didn't happen, but that was an aspiration. So at one level we do have, and we have a lot of welfare and developmental programs bringing out women even at the grassroots, at the most backward of villages. We have the panchayati system where 1/3 of the panchayat members are supposed to be women, and a whole lot of women are contesting elections at the local level and coming into the fora. So I would say there's a lot of things happening in India at one level, but more and more women are staking their claims and being assertive. The incidents of violence against them are also on the increase. Like you have a Dalit woman panchayat being paraded naked constantly this kind of reports coming in the press that she was beaten, she was made naked, and she was paraded in the village only because she used that power, being a Dalit and being a woman, into the panchayats. So in both ways, I would say the assertion comes at a price. Constantly, I mean, incidents of domestic violence, rape, sexual abuse in the streets, a whole lot of things that are also happening simultaneously. For instance, in law colleges, we have more women today in all the law colleges than men. For instance, what these women do after being law graduates is another issue, but at least they're there taking up this valuable space in law colleges. They're there, but then 10 years later, they may come to me as clients and victims of domestic violence too. That's like
I think we need to wrap up. I guess I just want to pull it out of India, and I'm thinking about the Polanski case, where there's again this commodification of a woman's situation. It's between her and him. But the media is on the camera, and in Europe, this is absolutely portrayed as typical American Puritanism. Look, the woman doesn't even mind anymore. She's gotten over it. Why doesn't America get over it? And it's portrayed as something that's typical American, whatever that means, religious, backward, conservative, puritanical. And what the woman would actually happen to her, or what she may have felt at the time, is taken out of the debate altogether. So it's not only India and backward places.
Exactly.
In the liberal media in Europe, very much so as well.
And you see the context of this date rape and what all happens. So even if you are like forward and dating, doesn't mean that sexual assault will not happen to you. If you are segregated societies, it will happen to you. If you are forward-looking societies and mixing and mingling, it will happen to you. It constantly happens. And so somewhere, I think, rather than saying women must change, I think it's time men change, and men change their approach towards women. I mean, we tried very hard to change women, and women are changing, but unless men change, this kind of tension and friction continues to be there. And when men get challenged of their patriarchal power, they hit back in a very vicious manner. So I think we need to work much more with men, South Asian, white, North American.
If it's in my hand, I'll make all the ministers and the heads women. That's what I love.